Hi, let us look upon the registration procedures. There is a separate registration procedure as per the GST law for existing registrants and new registrants. First, let us look upon the registration procedure for existing registrants. Existing registrants means those who have registered already under the existing laws. And existing laws include central excise law, VAT or sales tax, service tax, etc. They need not have to obtain fresh registration as per the GST law. All the existing registrants will be transferred from the existing law to the GST law through a procedure called enrollment. GSTN, that is GST network, will migrate all existing registrants from the existing system to new GST network. And for those registrants, GSTN will issue GST identification number and password. There is a condition that necessary documents and information should be furnished by those existing registrants through the GST network. And after verification by the proper authorities, the final registration number will be issued and registration formalities will be completed and the registration certificate can be downloaded from the GST portal. On any failure to furnish such documents or information, the GST identification number which was issued earlier will be cancelled automatically. When the existing registrants are enrolling themselves in the GST network, they have to mention all business places. It includes the principal place of business and additional place of business in the state. And these places, that is principal place of business and additional places of business, should be declared in the registration form. Service tax assessees may have a centralized registration. In that situation, where as per the existing law, where they have a centralized registration, they have to separately register under each state as per the GST law, because there is no provision for centralized registration as per the GST law. So, all service tax assessees who have centralized registration should register under each state government separately as per the GST law. One necessary document, or that is a requisite necessary for registration, is permanent account number, PAN. That is issued as per the Income Tax Act 1961. All persons, those who like to get registration as per the GST law, should compulsorily hold a PAN, that is permanent account number. The registration number as per the GST law is issued and it is based on the PAN number. But for non-resident taxable persons, PAN is not mandatory. But they have to provide necessary document that is mentioned as per the GST law other than PAN, and that should be provided with the government for getting registration. Another requisite for the registrant is that digital signature. Digital signature should be used for signing the registration form that has to be furnished for taking registration. There is alternative mechanisms including e-signature, which is based on Aadhaar card, that can be used instead of digital signature. But all persons, including companies or foreign company or limited liability partnership or foreign limited liability partnership, etc., and including the notified persons, has to compulsorily sign with their digital signature only. For them, e-signature cannot be used. After furnishing necessary information by the registrants through the GST network, that is a common portal, the proper authority should verify the documents, and if there is any error or any mistake or lack of any documents, he should inform the registrant within 3 working days. On getting any demand for furnishing necessary document or correcting any error from the department authorities, the tax authorities, the applicant, the registrant, should furnish those details within 7 working days. And the taxable authority should reply, should confirm the registration or otherwise the rejection thereof within 7 working days after getting that documents or rectifying the errors by the applicant. So in brief, if there is any error or any document is required by the taxable authority, it should be demanded within 3 working days, and the applicant should furnish those information or rectify the errors within 7 working days. And after intimation by the applicant, the tax authority should check the document or confirm the rectification of error within 7 working days. After furnishing necessary documents and uploading the other information whichever is required for registration by the applicant, the tax authority should approve or reject the registration form within 3 working days. On any failure, either regarding approval or rejection within 3 working days, it is deemed that the registration certificate is issued. The common portal will automatically issue registration certificate after 3 working days. The applicant will be informed about the grant of registration or rejection of registration through an SMS and by an email. The information, the communication will be done to the registered mobile number or the email ID of the applicant. The jurisdictional details also will be intimated to the applicant. The applicant can download the registration certificate from the GST common portal. The registration certificate, once issued, is permanent unless it is cancelled, surrendered, suspended or revoked. As I told earlier, the application by any applicant as per the GST law registration procedure can be rejected by the proper authority. Reasonable opportunity of being heard and show cause notice should be issued before such cancellation. And the applicant has the right to put forward an appeal against such cancellation. It is to be noted that if the application is rejected in one act, that is either the SGST or CGST Act, it is equally applicable to IGST Act registration also. That is, if the registration is cancelled as per the central government provision IGST Act, it is equally applicable to the state government act, that is SGST or CGST. There is a provision of suo motu registration. Suo motu registration means it is a situation where the department officer is proceeding with the registration procedure for any applicant who is not registered. It will happen in that situation where a person is actually liable to register as per the GST law, but he didn't register. In that situation, after finding out that that person is liable to register, the department officer can register that person after any inspection, search, etc. So, we have seen the registration procedures for existing registrants as per the existing laws and the necessary requirements regarding PAN and digital signature and other provisions in this video. Hope the points are clear to you. Thank you.